Hi everyone, thanks for attending today's session. For introduction, I am Pulkit Popli. I'm an intellectual property consultant with One IP International based in Sydney. And I have with me Olaf Kretschmer, who is a managing director of One IP International. Olaf has over 20 years of experience dealing with IP matters in European Union and Australia. Olaf is a registered barrister and solicitor in Germany. So, Olaf, today's discussion is on managing IP risks.
Right.
So, according to you and in your experience, what are the different kind of risks that a person face in terms of IP, and how do these risks change from stage to stage?
Good question, Pulkit. IP is a precious thing, and although you can't see it because it's an intangible asset, it's incredibly valuable and it can be incredibly dangerous for two reasons. One is that the law rewards the owner of a brand or the owner of a patent, the owner of a registered design for the relentless work building the reputation and creating this awareness, which is a tremendous job. The owner of that right eventually gets a monopoly right across the country. The person can prevent anyone from using that name, that invention, that design, and so forth. It takes years and years to build the reputation. So it's a well-deserved monopoly. On the other hand, and with that monopoly, obviously, the more successful a brand, a patent, and other kind of IP becomes, the more valuable in terms of like figures put to the text sheet this IP becomes. So think of, for instance, Microsoft or Apple. Apple is now one of the most valuable brands on earth. In the 90s, when they started from a garage, probably not so much. No one knew them. I'm sure there are people that were laughing about them using a bite of Apple logo for software. Look who's laughing now. So that is purely the reward that the law gave them for doing an awesome job creating this awareness, building this brand value, basically. So it increases by time, and this is coming back to my original point. It is a tremendous value even though you can't see it. On the other hand, it can be super risky to just getting started with, let's say Apple wouldn't have registered their trademark at the time, just started with a bite of logo, haha, how funny, we start using it, and by doing that, they put themselves into that situation where they inadvertently started to infringe existing registered trademarks or non-registered but well-known trademarks. So you always have to, when you establish a trademark or another IP right, you always have to look at what is already there, because the people being on the register, having done all that hard groundwork, will certainly not be pleased with you turning up the scene, now trying to take over. And that's what competition means. You're trying to take over their customers. You want to be better. You want to be more attractive. You creating that vision that your brand is worth more than the existing ones. Therefore, do me a favor, the first step is check on existing IP rights. The whole process is called due diligence, and not doing it will come back and bite you, because they would potentially sue you for damaging their registered trademark.
I think it's a very valid point. Going forward, the risk that you talked about is before someone decides on their brand or IP, they should consider checking it in the registers to see if it's registered. But assume, as a business owner, I have a trademark registered already. Is there any sort of risk that I'm still carrying with a registered trademark, say in terms of generalization of my trademark, or what risks as a registered owner can I have?
So even though, so basically you managed to register your mark, so you overcame that opposition period, no one was opposing your mark, you cheer up and say, "Hi, fantastic, I have my registration certificate." What it means is you got thus far. However, moving on from there, any existing trademark owner could potentially send you a letter of demand saying, "I am of the view that your registration must not have happened because it's actually infringing my mark," and would also be able to sue you even though you made it thus far and you ended up with a registration. Achieving a registration doesn't necessarily mean you're out of the danger zone. So other people might become aware of you later on and might choose to sue you then. Also, if your trademark is registered and you are aware of similar registered or pending trademarks and you do not take action, that dilutes the value of your trademark, and later on the infringing party could come back to you and tell you, okay, it's some sort of an implied license because you were aware of our existence, you didn't do anything at the time. That means silently you accepted our existence. So therefore it's always, when you have a registered trademark, you need to make sure that you do regular monitoring, that's what it's called. So you observe the register maybe in a time frame of every 3 months to see who has filed a new trademark application. Is this potentially infringing my registered trademark because it's deceptively similar to my mark? And then you have to do something about it. If you don't, you probably run the risk of diluting your mark.
This reminds me of that very funny video by, I think, Xerox, who publicized that the photocopying should not be called Xeroxed because overuse of a term as a verb would strip them of their trademark rights. Because if people in public, consumers, keep on using Xeroxed instead of photocopy, the court may say that the term has become a common use and they could be stripped of their trademark rights. So I guess fair enough. In terms of patents, commercialization and monetization projects that I've worked on, we have felt similar sort of feelings with respect to intellectual property risk. Even once the patent is granted, that patent could be revoked upon the request of an infringing party by going to court in almost all jurisdictions. And especially in terms of commercialization, the risks become very visible when you have to license or assign your IP, because no one wants to put their hand in a disputed IP. So all aspects of the IP is evaluated by the party.
Certainly.
Including the chain of title, that the title should be absolute. There should not be a dispute with respect to, even if it's a patent or trademark, there shouldn't be dispute. There shouldn't be any legal cases, lawsuits around that IP.
Fair point.
And apart from that, there is a qualitative and quantitative risk involved as well. So I think as practitioners or attorneys of firms who are drafting and filing the patents or trademarks should be very cautious that just getting the patent granted or just stepping that line is not sufficient, because if the IP is going to be commercialized, it may be challenged for revocation or on the qualitative analysis.
That's actually a good point. Great that you raised that now. So there's another stage of alleged security that people may feel like, what can possibly go wrong now because my trademark is registered. I have the certificate in my hands. The trademark office, at least within the 2 years following the registration of your mark, can at the discretion of the examiner, after a competitor files a respective application, at any point in time revoke your trademark registration, which means you're cheering up all the way thinking, oh, I've achieved registration. In fact, someone else is of the view it should not have been registered, and there is a two years time frame where the examiner could rectify an alleged mistake they made at the time, so it's by no means secure.
So I think the conclusion of this discussion so far is that no IB is risk-free at any time, but as a practitioner or a consultant, our job is to identify those risks and minimize for the clients.
Exactly. I mean, life is risky. The moment you're born, you can slip. You can, like, whatever you do, if you take actions, you put yourself to a certain risk. But let's distinct between mitigable, gettable risk or risks that are like, how can I say? Taking risks that you can where you can foresee the outcome, or calculated risks. That was the word I was looking for. Calculated risks, and like just crazy risk. Like crazy risk would be to invest $1 million in a brand and not registering it because the owners would believe, yeah, it's so unique and no one has that trademark, and we are fairly confident. We just skip trademark registration. That's what I call a crazy risk, because yeah, it's great that you're so confident, but it's very, very, very likely to fall on your feet, because simply there is a million trademarks out there, more than a million, and so you can do the maths. What's the likelihood of a problem arising? So you want to have your ducks in a row. You want to be prepared, having an application or registration in place. And then there's this calculated risk where, let's say you have your trademark is called Red Rocket and for clothing, and there is a competitor's trademark that you know, also selling clothing, footwear, headgear, called Blue Pocket. So that is it. To some extent, it sounds similar. It has a complete different meaning. Rocket and pocket and blue and red. Although it's dealing with colors somewhat, and we have identical goods. To some extent, there are connections that could lead to the view that there is indeed a likelihood of confusion, because people focus on like the names of colors and so forth. So it's not far-fetched to say that this could open a can of worms in terms of likelihood of confusion. But then again, because the sound is very different, the meaning is different overall. It is a risk that you can always almost neglect. You just have to be aware of it could potentially arise, but put it this way, simply because you believe you get up in the morning and you could potentially miss the bus and therefore potentially run in front of a car, just because you missed that bus wouldn't prevent you from getting up in the morning. So some risks that could happen, you just take them because they're so unlikely. And even then, when the risks materializes, you just want to be prepared. So think ahead, think of the risk, and put a strategy in place in case that risk would materialize.
I think the key word here is strategy. So as a consultant or as a practitioner, I guess your advice to fellow practitioners or consultants would be to identify the risks beforehand at each stage and strategize accordingly, so you can navigate those channels very smoothly. Put simply,
you identify the risk and you would say, okay, what do I do if this risk materializes? Yes. What is my response? Mm-hmm. So in your mind, you're already drafting the response, and if you have no idea what you would be drafting, don't file it.
Yes, absolutely. Thanks, Olaf. I think what we can conclude from this entire discussion is that no stage of IP could be 100% risk free. There could be smaller risks involved because it's just a course of business, and but the impact of those risks could be minimized with appropriate strategy and planning beforehand, and that's what our jobs as consultants to our clients is.
Absolutely, and here at One IP International, I think we put a great focus on not defending someone else's rights in court or actively enforcing them for alleged infringements or so. It's keeping the clients out of the danger zone, not getting into that scenario in the first place.
Right.
That's what we're aiming for. If it happens, we are prepared, because what I just said, like we figure out, is it a risk that that's a calculated risk, or is it a crazy risk? If we go ahead because it is a calculated risk, then in our mind, we have already prepared the draft letters that have to go out, and so we can deal with it and breathe very relaxed. And that means the client can be rest assured we are keeping them out of the danger zone because we know what to do. If, however, we would not know what we should be saying or doing, we don't touch it. Or it's the bitter truth, someone else was just quicker than you, please rebrand. No one wants to hear it, right. But it's a great deal here with our clients of speaking the bitter truth. Making them go back to the drawing board.
Right. Thank you, Olaf, for such insightful points for today's discussion.